morning, fourth period. Breaking news. The Supreme Court just held a hearing for Students for Fair Admissions versus the President and Fellows of Harvard College. Live at the scene, we have reporter Adrian Hayes to give us some more information. Take it away, Adrian.
Here outside the Supreme Court, the Students for Fair Admissions organization just accused Harvard College of the unlawful use of race in admissions. At this point, the Supreme Court has heard the arguments given by the Students for Fair Admissions, and we will continue tracking the case as more discussion occurs.
This is a very controversial case that has been repeatedly debated throughout history. Can you tell us a little bit about the other cases that were related to this one?
The organization's main reference was the infamous Grutter v. Bollinger's case, where the Supreme Court discussed whether Michigan Law School's use of race in student admissions is in violation of the 14th Amendment's Equal Protection Clause or the Civil Rights Act of 1964. The court ruled that affirmative action is not in a violation of existing laws as long as races are evaluated individually.
But things aren't so cut and dry, are they? What types of limitations are in place regarding affirmative action?
You're right. In the case of Fisher v. University of Texas, the Supreme Court also ruled that race-based admission processes must hold up under strict judicial scrutiny and the result must serve a compelling government interest. The Harvard plan, ruled lawful in Regents of University of California v. Bach, is used as a benchmark for race-based admissions. Harvard College's admissions were said to use race as only a factor used to effectively evaluate applicants in the context of their background instead of only looking at race.
Why is the Harvard plan relevant to the Grutter case?
The Students for Fair Admissions' main argument is that Grutter ruling was unlawful in regards to the Civil Rights Act of 1964, and that Harvard, originally the model for the correct type of affirmative action, has been using race in isolation to decide students' admissions. This will be the first time since the Grutter case where affirmative action as a whole will be officially re-evaluated in the context of the Civil Rights Act of 1964.
Thank you so much for your time, Adrian.